Good afternoon, everyone, and welcome to November. Tough to believe that October is behind us. If you are working through your trick-or-treating candy and maybe took a few pieces from your kids, you have maybe a day or two to wrap that up. It is terrific to be with all of you again, of course. And here in New York City, where I am coming to you from, it is pretty beautiful out there. Still feels like fall, and grateful that things are looking good as I peer out onto Midtown from where I'm speaking with you from. Why don't we get to the program, Kathy, and I can walk everyone through what we're intending to cover today. So thank you for advancing to the next slide. Appreciate it. And here, what you'll find is our agenda. I'm going to be talking about what we know with COVID and other public health relating matters. I'll quickly touch as well on the upcoming general election, which is a week away. And I'll also address the healthcare worker bonus program briefly. We have someone else very much steeped in that program, Seth Gilbertson, on here to present on a different matter. But Seth, I should note, just put out a really informative piece this morning on the fact that there is an extension now for another 30 days through November 30th, which we'll get into during my comments. Then we'll jump to Larry Fennell, who is a senior counsel with us, and he'll be talking about the Secure Act. And as I mentioned, then Seth will follow. Seth is back on the program, much as Larry is. And Seth's going to be talking about pregnancy relating protections under Title IX. And then Delaney Knapp, also a frequent guest of the program, will be talking about, in the context of, for instance, the 10-year anniversary of Superstorm Sandy, which all of us here in the downstate remember far too well. And with the context of the holidays upcoming, how can we make sure we're focusing our philanthropic giving in ways that are safe and going to reputable organizations? And then Lakshmi Maheshi is going to be speaking with us from our Westchester office about salary transparency activity, in particular with a Westchester focus, but also with some glancing at other jurisdictions, New York City and the like. So why don't we then move to my slides then, please, Kathy? I thank you for it. And on the COVID front, I mentioned to you when I was last here that the public health emergency was extended in mid-October. And we also know that means that generally, unless we get some sort of warning from HHS, excuse me, we're not going to see an end to that public health emergency anytime soon. And frankly, it makes sense as we're moving into a winter where there's a combination of flu, which is out early, and as well COVID with some new subvariants that again I addressed in my last comments to you that are putting pressure already on our healthcare system. And so we'll be watching all of that closely and keeping you all apprised. For the moment, there aren't new regulations or otherwise return to emergency orders of the fashion that we've seen during more restrictive times in New York State, where we're speaking with you from. It is also important, though, to know that in the context of all of this, the governor extended the state of emergency as far as healthcare staffing is concerned, excuse me, and that goes until November 26th. It's particularly germane to hospitals. There are, of course, limitations on how that applies to nursing homes comparatively. Why don't we go to the next slide, please? And on monkeypox, I've spoken with you about this before. Obviously, during the summer, there was some scary news and emerging trends that were certainly at that time not promising. But to the degree there's now much better control, the governor opted on October 27th to allow the state of emergency that was attendant to monkeypox to expire, which is good news. That means those emergency powers no longer are necessary. And doesn't mean that monkeypox has gone away, far from it, but it is under better management, or at least it's more predictable at this moment. And it's now going to be classified as a sexually transmitted infection, which has effects on those seeking healthcare services, including minors. So why don't we go to the next slide, please? I mentioned the healthcare worker bonus program, and I'll be brief here, encourage all of you to read Seth's piece, but the big news is many of us across the firm have been guiding any of you tuning in around this program going back to August. Initially, it was open for those with healthcare ties, whether hospitals or others with Medicaid billing activity. It then opened up to the educational sector in mid-October. There were between August and, certainly as I speak with you now, a number of different hurdles that have been raised up to the New York State Department of Health, as well as NYSA, the Education Department. They're not all resolved at this point. Some of them including means of accessing the portal where data concerning employees' activities during vesting periods and things of that nature. The portal has not been working as it should for many of those here on the line, for sure. We've been speaking with you, and we know across the state. And so late last evening, after standard business hours, New York State's Department of Health issued a extension, not to the end of vesting period 2, which officially closed in terms of the reporting requirements as of yesterday, but to give those providers, that are filing 30 more days. With any luck, the issues around access will have cleaned up by then, and we'll be watching it very closely. As I note, Seth and I are both involved in this, and there are some other attorneys you have seen here on the program, including Kat Grazios and Steph Fedorka, and we're working as a team to stay very much on top of all of these permutations. So that's what we have for today, other than a reminder to, as I note here, document. You want to be able to show what you have done to be compliant, even if the systems are not allowing you to go forward with your filings, whether that's taking screenshots of your efforts to get into the portal, making sure you're taking copious notes in terms of whom you're qualifying, on the state's behalf, that is, as employees that are appropriate for the program, et cetera. That's where we can be a further help to you. If you'd like, any of us available offline for further consultation. And with that, why don't we go to the next slide, where I will just briefly remind you of this event that I had mentioned in passing during my last hosting 2 weeks ago. Tomorrow, Colin Ahern, who is the newly appointed Chief Cyber Officer of the state of New York, is going to be speaking before a body where I'm a co-chair. Bond supports this work because it's important, helping healthcare providers at the intersection of cybersecurity build their knowledge and understanding of ways they can better fortify themselves. And the registration material is available through the links below, and we encourage you to sign up if that's of interest to you. You can also, of course, reach out to me to get further particulars about the work. Next slide, please. And then I would be remiss if I didn't talk about Election Day. It's coming up very shortly. We are going to see lots of discussion between now and the 8th around what is it that we're going to see at the federal level with our Senate. The balance of the Senate is very much in play. So too are many congressional seats. Of course, here in New York State, where I'm speaking with you from, the gubernatorial race is far closer, according to more contemporary polling, than many had prognosticated, several weeks and months ago. And so there are a lot of individuals from out of state, whether it's Governor DeSantis of Florida or President Biden, President Clinton, all of whom are lending their voices as we get nearer to the proverbial finish line. Early voting is open in those corners where you can do that across the state. And I know my kids got a sticker this weekend, so you can do that too if you have anyone interested in one of those. Without further ado, though, that's all I want to share for the election cycle for the moment, other than to note that we'll come back after the results are in with a comprehensive analysis of what might have changed and how across the state, let alone in our other listening geographies, the election results have meaning to your businesses and your operations. So with that, why don't we go to the next slide, please? And I'm going to introduce Larry Fennell, who is back with us on Business in 22. Larry is a senior counsel who is out of our New York City office and also with a foot in New Jersey. He is an expert in terms of our practices depth around retirement plans and other issues concerning employer obligations, and came to me with an interesting topic that I said, yes, Larry, it would be great to get you on the program to talk about. It's about part-time employees and thinking about employer obligations under the Secure Act. And so, Larry, I want to give you a moment to talk that through for everybody, and thank you for coming back on.
Hey, thank you very much, Gabe. Pleasure to be back. Good morning or good afternoon, everyone. I wanted to reach out as an issue, and doesn't necessarily require any immediate action, depending on your circumstances, but we'll get to that as we work through it. But the Setting Every Community Up for Retirement Enhancement Act of 2019, otherwise known as the Secure Act, was passed by Congress in 19. There's been some recent guidance pushing back the plan amendment deadline. However, even though from a plan documentation standpoint, there's been an extension, that does not mean that the actual provisions of the Secure Act are any less effective. Specifically today, I'm reaching out to talk to you about the long-term part-time employee rules, which were effective for plan years beginning on or after December 31, 2019. So effectively as of Jan 1, 2020. Presently, under, prior, and I guess presently in both under prior law, plans were always permitted to exclude part-time employees from their 401k plans if they didn't have 1,000 hours of service in any 12-month computation period. Under this new rule, in an effort to encourage retirement savings, what has been defined as long-term part-time employees must be permitted to participate in a 401k plan. So what does this mean? A long-term part-time employee is defined as any employee who has attained age 21 and has worked at least 500 hours a year in 3 consecutive years or 12-month periods, starting as of 2021. As a result, these individuals, if they meet this criteria, will be allowed to make deferrals. As part of the law, recognizing record-keeping issues, the first year in question for this calculation of 500 hours was 2021. And now in 2022 and then 2023, effectively, if you have a calendar year plan and you had the 500 hours per year in these 3 consecutive years, you'd be allowed to make deferrals to a 401k plan in 2024. These questions, these years also would come into play for vesting purposes to the extent a part-time employee needed years of service for vesting criteria. Notably here, this is just an elective deferral provision. Any long-term part-time employee is not required to receive any matching contributions or profit-sharing contributions. However, these years of service, if they later were to transfer full-time status, may come into play. Special rules apply there. If this were to pertain to you, we'd recommend reaching out and following up with us about your situation. Specifically, as an aside, record keeping being an issue, if you haven't been keeping track of hours, there might be a desire to, let's just amend our plan to allow part-timers to apply with this criteria. However, under the Secure Act, you would get non-discrimination and top-heavy plan testing relief for long-term part-time employees. Whereas if you amended your plan, you may not receive that specific relief in question, and you may have a hard time excluding a long-term part-timer from receiving employer contributions. So I think it's important to take a look at this and make a determination of, what you can do to ensure that you're calculating hours correctly for these individuals. Now, here's the practical piece here. We're in November of 2022. And if you haven't been counting hours, it may well be difficult to go back and actually count hours. As I mentioned, doing a plan amendment at this point in time, although would allow those individuals into your plan, you may not get, or you would be potentially subject to testing on those individuals for employer contributions and other issues, which may cause issues for you in passing your non-discrimination testing and other compliance testing. So what do you do? At this point, we recommend using best efforts and acting in good faith to try to determine, if you had long-term part-time employees who met this 500-hour criteria going back into 2021 and thus far within 2022. We recommend, reaching out to your vendors if you have a payroll provider or other vendors who might be providing services to your company. Find out if they have a way to determine how to calculate hours. Looking internally to see if you have maybe alternative sources that provide, some sort of documentation regarding hours, so you can reasonably rely on it to make this determination. But in essence, we hope there's going to be some government guidance on this, but for the time being, just be aware that if you have individuals who are working on a part-time basis and who have been working with you for a long time, going forward, effective as of 2021, you need to track the hours for these individuals. And if they do meet the criteria of being age 21 with 500 hours a year over the course of 3 consecutive years, you would theoretically have to provide these people with an opportunity to make elective deferrals into your plan. And not even theoretically, you would have to provide that opportunity to them to make elective deferrals. So if you have any questions, please feel free to reach out. We know this is potentially a difficult administrative burden for our clients. And if there's any way we can help, we'd be happy to discuss this with you further. But thank you very much, everyone. And thanks, Gabe, for having me on.
Of course. And Larry, really useful to raise this to the group's attention. Quickly, there are a couple questions that have come in. First, does this apply to 403B plans, as far as you know?
As far as I know, it's 401k specific. I could touch base. If anyone has a 403B plan and has a question, please feel free to reach out. But as far as I know right now, this is a 401k centric requirement.
Yeah, and there's another similar question around government agencies where I'm assuming those same kinds of carve-outs may apply. But within the chat, Larry, you'll find some of these questions, and no doubt, to our viewers, Larry's going to get back in touch with you to make sure that you have answers. And Larry, thank you again for coming on. It's always appreciated. And with that, let me then please turn to our next speaker, Seth Gilbertson, who is back with us. As I mentioned, Seth is very involved in the healthcare worker bonus story as far as we're working to get answers for all of you. But Seth's practice is far broader than that. And he also is here to give us updates relating to pregnancy-related protections in Title IX, which Seth is prepared to walk us through. And Seth, really glad you can be back. Welcome from our Buffalo office. We're glad to have you.
Thanks for having me. Next slide, please. So I don't have anything new to share here in terms of brand new law or even guidance that's substantially different than prior guidance. But we did think it was important to bring to you because frankly, the U.S. Department of Education Office of Civil Rights thought it was important to drop a new fact resource on us on October 4th, a few weeks ago, and I say here reiterates, and that's exactly what it does. It doesn't change the law, but it sort of draws our attention back to the law. They call this a fact resource, so it's not a press release, it's not a fact sheet, it's not a dear colleague letter, it's something else, something new type of guidance, but clearly, they wanted to put this issue in front of us. It's something that the current administration has been focused on, I think, even before the Dobbs decision, but especially since the Dobbs decision and the drastic changes in reproductive rights that are going on across the country. And I think we need to listen. The way I look at this is sort of like when you drive by one of those big speed limit signs that tells you how fast you're going. It's got a flashing yellow light next to it. Those don't change the speed limit. If it was 35 before, it's 35 after. But somebody wants you to pay particular attention to the speed limit in that area at that time because they're giving away a lot of tickets. They're getting a lot of accidents. Residents are complaining. Something's going on, and it's probably a good idea to look down and make sure you're still going the right speed limit. So I think that's what's going on here. They want us to pay attention to it. And obviously there is an emphasis within these on termination of pregnancy. In fact, in the third sentence of the new fact guidance, the fact resource, they draw the specific attention to the protections that are in place for termination of pregnancy in particular. Next slide, please. There are really three types of protections that that do come into play under Title IX related to pregnancy and related conditions. Exclusion, a prohibition of any kind of exclusion, both within education and employment for educators. So if you're covered by Title IX, this would apply to your employees. Provision of benefits to both students and employees need to be equal under Title IX for pregnancy and related conditions. And then leave, there's some leave is probably the biggest one where this comes into play for both students and employees, and I'll talk to you about that in just a minute. First one, obviously, there is maybe it's not obvious, but there is clearly a prohibition on discrimination and exclusion of both students and employees for pregnancy and related conditions, and so you can't deny someone employment, you can't deny someone admission, you can't kick them out of school, or obviously try to take employment actions against them based upon pregnancy or related conditions. When I say that over and over again, pregnancy and related conditions, this list here that's underlined is what all is included in that. And again, that does include termination of pregnancy and recovery therefrom. Next slide, please. So benefits. We need to provide equal benefits if you're covered Title IX employer or educational entity. Then you need to provide the same benefits to pregnant and individuals with who are pregnant or have related conditions as you would to other students with temporary disabilities or other employees with temporary disabilities. So there are some permutations of this that may apply particularly to religious institutions. If you have questions on those, a little beyond the scope of today's discussion, but if you have questions on those, please reach out. Next slide, please. And then, as I mentioned, leave policies are probably the biggest one, particularly with regard to students where this comes into play. We are required to provide leave for students for as long as medically necessary for pregnancy and related conditions, which again would include termination of pregnancy. And then when the student returns, we have to find a way to return them to the status that they had when they left. So basically, a lot of times this means trying to keep the student up with our cohort, make sure they graduate on time, make sure that they make up, whether they be clinical hours or tests and exams and things like that they've missed during their time away. So you're going to have to work with their faculty to make sure that we kind of bring people back up to speed and they're able to resume their education. Next slide. Similarly, with regard to employees, we need to provide leave even where leave would not otherwise exist. So this is kind of a unique area. It's almost like an addition to FMLA or PFL that exists for employers, or for educational institutions who are employers. So you would exhaust all your regular types of leave that you would already have in place. And then if you have an employee who maybe is not FMLA eligible or has used up all their accruals, this would kick into play and you would have to consider a new type of leave or additional type of leave for employees who are pregnant or have related conditions. And that's all I had to share for today. Thanks, Gabe.
Seth, thank you. Really glad you're back with us, and you're always welcome to provide additional updates. And I now have the pleasure of introducing Delaney Knapp, who is our third speaker from the Bond team, in addition to myself. Delaney is with us from our Albany office, and Delaney also has presented before this group a number of times. And as I mentioned, she has really important guidance as we think about charitable giving in the context of too many issues recently, whether natural disasters or other types of upheaval that make us all want to give, but the idea is how to do it smartly. So Delaney, the floor is yours, and we look forward to learning. Thank you.
Thanks, Gabe. So as Gabe mentioned, unfortunately, there are a lot of things kind of vying for our attention right now in the media and occurring both within our country and around the world. We first published an article regarding informed giving in light of the escalation of the war on Ukraine. a couple months ago and recently re-released in light of Hurricane Ian and with a different focus kind of on how to make your charitable giving decisions following natural disasters. Next slide, Kathy. So in times of crisis, new nonprofit organizations and other initiatives are often launched quickly, and there's compelling cases for your contributions. However, the urgency and speed with which you're asked to make decisions can make deliberating and choosing an organization to give to much more difficult. So the question we tried to answer in our articles and through this presentation is, how can you conduct meaningful diligence quickly, especially when there are concerns about the human impact of delay in giving? Next slide. So first, you're really just trying to be reasonable in your due diligence. All things being equal, you're seeking to give based on more information rather than less. And there's kind of this 80-20 rule with respect to 80% of the value that you're going to be able to get from doing research, you can kind of get from the first 20% of effort that you put in, especially with charitable organizations, 501c3s. A lot of their documentation is publicly available and you can find it pretty quickly. And that's kind of how we're going to walk you through where to look. Ultimately, when you're thinking about giving during times of crisis, if you feel like time is critical, look for something that makes you pause, that maybe confirms your expectations or leads you to more questions about an organization, or gives you information that you wouldn't have had if you hadn't looked until you feel that you're ready to make a decision. Next slide. And proactivity is really going to be your best method of avoiding fraud, malfeasance in giving, or other scams that kind of pop up around this time. And this really means just independently seeking out charities and fundraising campaigns rather than responding to unsolicited emails or social media requests. And so, you can go Google yourself, but it doesn't mean you necessarily have to start from scratch. There's plenty of reputable news sources, civic groups, other nonprofits. The New York State Bar Association put together a list in response to the war on Ukraine. So you can kind of use those as a jumping off point and then go from there with your research. Next slide. These are a few resources that we use where you can find information pretty easily and quickly. GuideStar, GiveWell, and Charity Navigator, all great resources. And I know specifically with GuideStar, you can create a free profile. You just type in the name of the organization you're looking up, and it has kind of their fundamental information as well as some of their financials from usually the past 3 years. Next slide. And so part of this diligence is going to be checking basic compliance. It's pretty quickly to review an organization's legal compliance record and eliminate any organizations with major red flags. So in most cases, an organization is going to be registered with some kind of charities oversight agency in New York. That's going to be the New York Attorney General's office, their Charities Bureau, and they're also going to be filing annual reports with the IRS, and those are both publicly available in each of those respective websites. So if you're going to the AG's website or the IRS website and you can't find an organization you're looking to donate to, that should be your first red flag. In some cases, however, especially when something happens and there's an immediate need for aid, a new organization could be formed and therefore it's going to have limited information available. This doesn't necessarily have to be concerning to you, but there are several factors you can kind of use to evaluate whether or not it would be a good place to donate to. So looking at the organization's leadership and whether or not they're experienced in operating nonprofits, looking at the organization's infrastructure for providing aid. Are they more of a boots on the ground model, or are they just providing financial support? And so these questions and these answers should inform your decision about donating to any newly formed organizations versus an existing organization that has been around and has an established track record. Next slide. And so these are just screenshots of the two agencies I mentioned. So that's what the Charities Bureau website is going to look like. You can just type in the organization's name. Usually it has their certificate of incorporation, their bylaws, their 501c3 letter. If you're not seeing those things, you might be a little cautious. And same thing with the IRS website. That's just going to have their 501c3 letter and their annual filings though. Next slide. Now, in this presentation, there's not a lot of space to go through what you can find in terms of financial information. We do that in more detail in our articles. We kind of go line by line through the annual information returns, the tax returns that are filed by 501c3 organizations. And like I said, those can be accessed either directly through the IRS website or through GuideStar. Next slide. What we can point out, what's easy enough to cover, are just a few things that you can look for in the first few pages of these reports. So first, looking at the mission statement or the statement of the organization's program service accomplishments. This can tell you if the organization's purposes are aligned with the needs of those affected by the current crisis. If you're looking to donate to an organization to assist with aid following Hurricane Ian, you're going to want an organization who's had experience doing that or whose purposes are aligned with that, and maybe not a different type of crisis or aid need. And also, is the organization already active in the specific country or region of interest, or have they never provided services or aid to that region prior? We know that the learning curve can be very steep for organizations, so knowing where an organization may be on it can be highly valuable to you. Next slide. You can also find out the total number of employees and volunteers. That can lead you to figuring out what the capacity is for them to provide services or aid. But just because there's only a few employees or volunteers doesn't necessarily mean they're not capable. If you're looking at a boots on the ground organization that is located in a region and providing direct service, you're going to want a larger number of employees or volunteers. On the flip side, if their model is one of just strictly providing financial support, you probably only need a couple people. You can also find out information about the revenue and expenses, whether an organization is running a deficit or a surplus in their current or most recently completed year, and whether that has continued in the most recently preceding years as well. That can give you some information about their financial management, which is something you're going to want to know about when you're looking at giving your funds to these organizations. Next slide. And you can also find out information about the salaries of employees, compensation and employee benefits, looking at how much executive leadership and staff are getting paid. Although it's important to remember that compensation does not exist in a vacuum. And so the size and sophistication of an organization and their activities is going to be important to consider, not just the numbers themselves. Next slide. Lastly, our concerns really in times of crisis are with commitment and efficacy. So once you've evaluated an organization's compliance and their financial fundamentals, you should consider their commitment to use your contributions for their intended purposes. This usually means their ability to offer immediate aid that will provide the most benefit at the lowest cost. Whether an organization has experience addressing a specific humanitarian cause, an established history of successful fundraising and providing aid during crises, and infrastructure within the impacted region should all aid in your selection of a charity or fundraising campaign. Next slide. And ultimately, just remember that this process is a means to an end. I know it seems like a lot, but you'll get pretty quick with it over time. And also just remembering that because time is so critical in these circumstances, we don't want to advocate for paralysis by analysis. The diligence we've talked about can be accomplished in just a few minutes, keeping in mind that the goal of the process is to glean information quickly, to inform your choices, but not to achieve any kind of certainty. Next slide. And that's all I have.
Thank you so much, Delaney, for that really helpful coverage. During the chat, function or monitoring the chat function, I should say, we already received feedback that it was really helpful information that at least one viewer hadn't heard or seen before, and we're hopeful that's the case for many more of you. Delaney, you're always welcome back here to provide updates in the important space where you do your work. So thank you. And now let's move to our final speaker, Lakshmi Merheshi, who is with us from our Westchester office. Lakshmi is a senior counsel as I, and she's here to tell us a bit about salary transparency with a focus on Westchester, but as I noted in my opening remarks, with an awareness of some of the other jurisdictions where new standards are now enforceable or imminently will be. So thank you, Lakshmi, for being on. Welcome to Business in 22, and we look forward to learning.
Thank you for having me. Good afternoon, everyone. So a part of a national trend in the development of pay equity laws include wage transparency. As we know, legislatures are now moving away from employer privacy in an effort to address inequitable wage gaps. And so, as you may know from the presentation of other prior bond attorneys, such as Seth Gilbertson or Lisa Feldman, the New York City law on salary transparency goes into effect today and requires that nearly every company be required to include salary ranges for job postings, both those shared on public sites and internal sites, and even for those jobs that offer a hybrid schedule or can be performed fully remotely. So similarly, employers who employ individuals who work in Westchester County should be prepared to comply with a similar wage transparency law that goes into effect as of November 6, 2022. So can I have the next slide? So the key points to be aware of as it pertains to the Westchester County transparency laws is that, again, it goes into effect as of November 6, 2022. There are still several ambiguities within the law. It does apply to all private employers with more than 4 employees. This does not include independent contractors, and the law does not specify whether owners are included in the 4-employee threshold or whether all 4 have to be physically located in Westchester, sort of the nexus for this law being in effect. It does apply to any job, promotion, or transfer opportunity. So that means full-time, part-time employees, internal and external postings. What it does not apply to is temporary employees. The application of the law is relevant for positions that are going to be performed in whole or part in Westchester County. So that's whether it's from an office, in the field, or remotely. So it does apply to remote positions. Does it apply in those instances where a mom and pop shop has posted an informal poster, a help wanted sign that's affixed to the premises of a building? Does not qualify as a posting for the purpose of the Westchester law, as long as it doesn't reference particular positions or any meaningful information. Ultimately, what does need to be posted is the minimum and maximum salary for a position, and that range can extend from the lowest to the highest salary that an employer in good faith believes that they would pay as of the time of the posting. The Westchester law does not specifically address those instances where there is no range and it is a set salary without flexibility. For example, if it's going to be $20 an hour. And so that's not explicitly addressed. Best practice would be to specifically delineate, here's the salary. What the law does preclude employers from doing is it precludes employers from relying or inquiring into the wage history of the prospective employee. So this is a little nuanced because it doesn't preclude disclosure by a prospective employee during the course of negotiating. So an employer cannot request that information, but an employee may say, well, at my last position, here's what I was compensated. I would like that to be matched, or here's my expectation. And that does not cause a violation of this statute. What is considered a posting is a written or printed communication, whether it's electronic or hard copy. It does have to include listing for a specific position. The Westchester law provides for civil penalties up to $250,000. So if we could go to the next slide. So it's worth clarifying, the New York iteration of these transparency statutes has not yet been signed by the governor. It would go into effect 270 days after signature. So until then, the various city, county specific statutes are the ones that apply in New York State. That is New York City, Westchester County, and Ithaca. It is worth noting as well that the Westchester County law has what's known as a preemption clause, which provides that the Westchester law will be null and void if New York State or a federal law is enacted that incorporates substantially similar provisions. As of now, because there's no sort of preempted New York State or federal law, the Westchester County law applies. The laws are substantially similar in many instances as it pertains, to the effective date. We're seeing rollouts. Ithaca's statutes went into effect in September. New York City is in effect as of today. Westchester starts on the 6th. It does cover 4 is the magic number, exempt employees or temporary employees, and across the board, it applies to any job, promotion, or transfer opportunity. Some of the key differences include the ambiguity areas, which is the Westchester law doesn't clarify what compensation needs to be included as a part of the post, whereas the New York City law specifically delineates that it is the base salary that needs to be posted. It doesn't contemplate items such as overtime, vacation, medical insurance, or any other commissions, bonuses, or meals or lodging. Who can file a complaint? Again, nothing specified in the Westchester law. In New York City, only current employees can file an action against their employer with the New York City Commission on Human Rights. The violations range. So in Ithaca, which is the lowest potential penalty, it's up to $500. In Westchester, it goes up to $250,000. The New York City provision does provide an opportunity to correct, and there's a 30-day window, so you can avoid penalties. The key takeaway is that at this juncture, employers who are in New York City, Westchester, or Ithaca should review their current postings and update them to include compensation ranges. This should include jobs that are posted on the company's website, intranet, any other online forums such as LinkedIn or Indeed. One clarification is that despite the name, pay transparency laws only cover job postings. They do not require you to publish or otherwise disclose existing payroll information. So fundamentally, employers should stay on notice and consult with the bond attorney that you're in touch with if you have any questions or concerns on how to comply with these statutes. And Gabe, are there any questions?
Sorry, thank you so much. There are a few questions which I think will be in best position to answer offline, given that it is at 12:45 right now, when typically we wind things up. But I have conveyed those to you, Lakshmi, and you'll have the opportunity to reach out to those participants through email or otherwise. And so for those of you who are waiting for further guidance, please expect to hear from Lakshmi. And otherwise, I encourage all of you to reach out to any of the bond attorneys that you heard from here today. If you have questions, we are here to help you as always. I will be back with you on November 15th, 2 weeks from today. Adam Mastroleo will be your host next week. as I noted, will provide you with updates on the elections and whatever else is topical when we come back together. And in the meanwhile, wishing you all a good afternoon, a great start to November, and we'll be in touch with you soon.